The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to the Kansas Supreme Court. We'd welcome both counsel and those who are watching us through our Supreme Court live channel. We'd ask Mr. Doug Shima, the clerk of the appellate court, to please read the 11 a.m. docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Wednesday, February 3rd, 2021 consists of one case. Appeal number 120783, State of Kansas versus Patrick M. McCroy, Reno County, briefs both sides. The appellant, State of Kansas, has reserved 2 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Would ask counsel to please state their appearances.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. I'm present and ready for argument.
May it please the court, Shannon S. Crane on behalf of Patrick McCroy, present and ready for argument.
Thank you, counsel. Ms. Chalmers, you may proceed with your argument.
Thank you, Your Honor. This case is in front of this court to determine whether or not the state has jurisdiction to appeal a motion to correct a legal sentence. It came before the court based on graduated sanctions. The district court imposed a 180-day section for the second time. The state argued that or believed that wasn't authorized based on the statute. It filed an appeal to the Court of Appeals, and the Court of Appeals found no jurisdiction. The state is simply asking this court to file its longstanding precedent set forth in Scherzer and before that, because following such precedent promotes the systematic stability in our legal system. Further, more harm than good will come from not relying on Scherzer. Not only will the state be prejudiced, the defendants will be prejudiced as well. This court has repeatedly relied on Scherzer. It did so at least as recently as 2018, and it has numerous cases that state that a motion to correct a legal sentence can be raised for the first time on appeal, not through briefing or any motion filed in the district court, but just, in a brief filed at the Court of Appeals or the Kansas Supreme Court. It doesn't have to be raised below.
Ms. Chalmers?
Yes, Your Honor.
So if I understand you correct, I don't mean to jump in so soon, but you're conceding the statutory analysis of the panel below, but arguing that stare decisis warrants our continuation of previous precedent to the contrary?
I believe I'm relying on the statutory analysis that was set forth by this court in Scherzer. I'm not agreeing that the Court of Appeals' statutory analysis was correct. Or I don't believe that. That's what I'm trying to do anyway. But to the point that the defendants will be disadvantaged too, as this court knows, when a plea is entered, jurisdiction is extremely limited, but sentencing challenges have been allowed. So let's say a defendant is sentenced, and then a week later, something like Weetrick comes out that fundamentally changes a defendant's sentence in the sentencing process. That defendant can't file a motion to correct a legal sentence because by this court's precedent, the sentence was legal when it was pronounced. But typically the defendant could file a direct appeal and then raise the issue. But if the defendant, if there needs to be another procedure vehicle, if the legal sentence statute and KSA 60-2101 don't work, that defendant has no ability to get a remedy either. Both defendants in the state for at least 20 years and longer have been relied on the rule that this court has said that a motion to correct a legal sentence can, in fact, be corrected at any time, including for the first time on appeal. And the state should still be able to rely on that rule.
Ms. Chalmers, why is it that a defendant can't challenge the illegal sentence? Their appeal rights are not necessarily similarly situated. Like, for example, under 223602, subsection A defines the defendant's statutory right to appeal, but subsection B provides what appears to be a much more narrow scope of appeal rights for the state. Can you explain your argument in a little more detail as to why defendants are?
Oh, sorry, Your Honor. I'm not saying that a defendant who had a conviction and was appealing a conviction through a jury trial, they'd be able to raise it because their rights is limited. But a defendant who enters a plea has much more limited rights. At that point, KSA 2236, I'm going to get all my statute numbers right someday. KSA 223602F would kick in, which limits sentencing appeals, and you have to go to the other statute that does authorize departure appeals, but doesn't allow a defendant to challenge a sentence if the defendant agreed to that sentence, if it was this agreement between the state and the defendant, or if it's a presumptive sentence. And so Duncan is an example of a decision that this court would have to find was wrongly decided, because Duncan is a case where this court said, well, it's a motion to correct an illegal sentence, so you can raise it for the first time on appeal, despite the fact that there was an agreement to the sentence. That case is wrongly decided. Numerous other cases are wrongly decided. That Schwarzer is regularly cited, and I'm sure this court is fully aware of how many times it has said, even recently, that a motion to correct a legal sentence can be raised for the first time on appeal. So I'm not saying defendants will never be able to appeal them, because they will, as long as it's not a plea, essentially. So defendants who plead then will have less rights than defendants to go to trial.
And then under 216820, is it your interpretation that those appeal rights, like in subsection E, are limited to direct appeals only because it's an appeal from a judgment of conviction?
Yes, Your Honor. The judgment of conviction typically has been interpreted to mean direct appeal, which means that it's unclear then if a defendant files a motion to correct an illegal sentence and loses, if the defendant's going to be able to appeal either. They can get it through a direct appeal, but I'm not sure what statutory authority they have to do a motion to correct a legal sentence either at this point, if this court doesn't just follow its longstanding precedent in Schwarzer.
I'm having a little trouble defining what the district court did as a sentence. Can you help me out? It does seem to me that what the court did was simply impose a sanction for a probation violation.
Yes, and I know that the Court of Appeals, there are Court of Appeals panels below that the state has said, or has said to the state that this isn't a motion to correct a legal sentence. I think the defendant made those same arguments in his Court of Appeals brief. To me, it's still a sentence because the sanction is in fact eating up the defendant's time. I just don't see how a sanction isn't part of a defendant's sentence. Probation is part of a defendant's sentence. The sanction itself goes to the sentence. If in fact the sentence is ever imposed, he'll serve less time because that time counts as time served. I'm aware that there's contradictory case law on that, and I just don't understand how, when you have a sentencing statute, you can't use a motion to correct an illegal sentence when the district court clearly did something that's not authorized by statute.
Is there any case law authority that says that what the district court did, which is impose a sanction for a probation revocation, is in fact a sentence?
I am not aware of, I don't think this court has ever addressed the issue, and the Court of Appeals, notwithstanding this case, I don't think they have a case that says that. I can't immediately come up with one, Your Honor. But a sanction, I struggle to see how it's not a sentence, but I could be wrong. If there are no further questions, the state would just argue that the Court of Appeals was wrong when it determined it did not have jurisdiction, and this court should file stare decisis.
Can I ask you one other procedural question? Was the argument, the legal argument, even made before the district court? I know there was an objection because, or not an objection, but the argument that, hey, you tried this once before, the 180-day sanction, and it didn't work. But what was the actual legal argument advanced and preserved in front of the district court?
It is my reading of that transcript that the state didn't say anything explicitly like this is an illegal sentence. You don't have authority to do that. They just asked for the underlying sentence to be imposed.
Any other questions? Anything else, Ms. Chalmers?
Not right now, Your Honor. Thank you.
Ms. Crane?
Thank you. May it please the court. I believe that the Court of Appeals was correct in their analysis of the jurisdictional issue in this case. The right to appeal is statutory and it defines who can appeal and what you can appeal. It is very limiting. The statutes that we do have in front of us, we have 223602, which provides a list of things that can be appealed and is very limiting to the state on what they can appeal. We then
Counsel,
have-
can,
Yes, Your
can I
Honor.
can I follow up with a question that's been bothering me during the
Okay.
course of the last argument and this one? And that is, if we agree with you and if your argument is correct that the state is limited to the enumerated instances in 3602B, that's your argument, right?
Essentially.
Appellate. So, but I take it you would agree that once the appellate court has jurisdiction, the motion to a motion to correct an illegal sentence is a viable motion from either party at any time, if the court has jurisdiction.
And sorry, Justice, I need you to clarify. Do you mean the appellate court has jurisdiction or the district court has jurisdiction?
If the appellate court has jurisdiction, a motion to correct would be a procedurally appropriate vehicle at any time, even on appeal. That's what
I don't, yes, I don't believe that filing a motion to correct the illegal sentence by the state would confer jurisdiction upon the Court of Appeals.
Right. No, my question is, once they have, if just assume for purposes of my argument that everyone agrees the appellate court properly has jurisdiction. At that point, I've not heard anyone suggest that a motion to correct an illegal sentence is inappropriate, because our case law has pretty clearly said it can be taken up at any time, even on appeal.
The case law that discusses that is the defendant appealing, not the state. There's only been 2 instances where the
Well,
state.
let me cut to, I guess, what my real question is, which is, here's what's bothering me.
Okay.
If we create a circumstance where the state is required to invoke to the jurisdiction of the appellate court in some fashion, just so that it can have a vehicle to raise its illegal sentence claim, my concern is that why wouldn't the state just reserve a question in every single trial, just as a way to preserve appellate jurisdiction? Okay, well, we reserve a question on whatever. And now at least we've got our little toe in the door, so to speak, so that if we have to, we at least have appellate jurisdiction and we can correct the sentence. I mean, that seems to me to be a potentially unintended consequence of what we're discussing. I just wanted to get your thoughts.
Yeah, and I don't believe that filing a motion or reserving a question is going to work in this instance, because you have to have some issue before the court at the time, and that's not an issue in front of the court at the time. The statute regarding correcting an illegal sentence also has what the Court of Appeals said is that statute is there, but that is a way for them to bring it in front of the district court. It does not give jurisdiction to the appellate court. And one of the things I've noticed is that statute to correct an illegal sentence also talks about there has to be notice and an opportunity to be heard unless the files and records conclusively show the defendant is not entitled to relief. That the defendant is not entitled to relief, not the state. And it also doesn't have any appellate rights attached to that. The other statutes that do give the state rights to appeal specifically state that, such as in the departure statute that allows them to an appeal a departure. That statute in itself has appellate jurisdiction in there. The one to correct an illegal sentence does not, and talks about the defendant is not entitled to relief, not the state. And also you have to have a motion and give the district court the ability to correct any illegal sentence. And as was pointed out earlier, the state did not do that in this instance. They did not do that, nor did they reserve this issue for appeal. They simply filed an appeal saying that it's an illegal sentence. I also don't believe it's an illegal sentence, as to earlier conversation, because it's not a sentence. A sentence is what is pronounced from the bench. And as my brief indicated, it has to be, it's the final judgment in a criminal case. That's what the sentence is. And that's from State v. Mason.
Ms. Crane?
Yes.
Can you help me understand, or your position in response to Ms. Chalmers' argument that reversing our precedent would limit even the defendant's right to an appeal, an illegal sentence outside of a direct appeal? Is that a correct reading of the statutory schemes?
A direct appeal of the conviction, I don't believe so. I believe they can file a motion to correct an illegal sentence. If that's denied, then they would have the authority to appeal that under 3602, which gives them defends broad rights to appeal.
But subsection F of 3602 does seem to address those sentencing errors and directs them back to 216820, which then includes the language that seems to limit the appeal rights to appeal from a judgment of conviction.
Yes, I understand that. I do believe, though, if that motion to correct illegal sentence is filed by a defendant and denied, that they would still have the statutory authority under 3602A to appeal that, not under F. I would just follow up with, I believe this is an issue for the legislature if they want to allow the state to appeal illegal sentence pursuant to 223504, that they can come back and rectify that. But as the state of the law is now, that statute does not give them the authority to file an appeal. It does not give the Court of Appeals jurisdiction to hear that issue. Be glad to answer any more questions anyone has.
Are there other questions?
Thank you.
Ms. Chalmers, you reserved.
I would first point out that I believe that KSA 223602F is the more specific statute, and it says an appeal by the prosecution or defendant relating to sentences imposed. An appeal that is trying to deal with the illegality of a sentence is unquestionably related to a sentence imposed. What the result of this is essentially no one gets to appeal a motion to correct an illegal sentence if this court goes with the Court of Appeals opinion. I don't think that is something this court should do. I think that the legislator has relied on stare decisis by not going in and modifying the statutes to specifically allow jurisdiction. This court's precedent has told them they didn't need to, so they didn't. And this court should just follow its precedent and short serve. Thank you, Your Honors.
Any additional questions?
I think Scherzer also relies on 60-2101. Is there any independent jurisdictional basis through that statute, or do we really need to hone in on 3602 and wherever that takes us from there?
I do think there is some jurisdictional basis in 60-2101. I do think it's interesting that 60-2101A, which relates to the Court of Appeals, says in any, I'm trying to pull the statute so I get the language right. It says in any case properly before it, and subsection B, which is this court, does not have that language, which seems to indicate that maybe this court is a better court to attempt to do an appeal to a motion to correct a legal sentence, potentially, if you don't just say that KSA 223504 is good enough to give us jurisdiction. So I do think there is additional analysis that you can do in 60-2101, as it does talk about this court and the Court of Appeals' jurisdictional ability to hear cases.
Help me out, because I'm going to go back to what I asked you before. Because none of this was sitting right. And I went back, I went back and looked at the Marinelli case from 2018, where we had to talk about whether registration was a part of the defendant's sentence or not. And so, and as defense counsel said, a sentence is what gets declared by the court to indicate what the punishment is for the crime that the defendant's been convicted of. And once it's declared in open court at the time of conviction, it can't be modified. And it seems to me you're saying that the operation of 2237-16, which is the sanctions that permit, that go into play for probation revocation, amounts to a modification of the sentence. And I think that would mean that 2237-16 is illegal, wouldn't it? Because you're not allowed to modify a sentence once it's been pronounced from the bench.
I think sentencing and probation are kind of not totally comparable to each other. Yes, a sentence to prison cannot be modified. A probation sentence, there's ample authority for modifying that. This court allows the defendant's sentence to be reduced after a probation violation revocation. So there is modification built in, and we've never said that that's illegal. So yes, the court can, in probation context, modify sentences if there's a revocation. And in some cases, without a revocation, there's statutory authority to shorten a sentence, even felony sentences.
Yeah, I'm still having trouble declaring what the district court did to be a sentence or even a modification of a sentence, as opposed to a sanction for the defendant violating a condition of probation. And I'm not hearing anything that tells me that that is a sentence.
That's fair, but I'm just not sure how it's not part and parcel of a sentence. It's a sentencing statute. It tells you exactly how you treat a probationer while they're on probation. And if apparently district courts don't have to follow sanctions at all, why not just give them discretionary authority and then no one can review anything? But they set forth the rules, and then I'm of the opinion anyway, that the state should have some ability to enforce that so that everyone within the graduated sanction scheme is being treated relatively equally if they're on equal footing. Not just a district court judge can decide, I don't like the sanction setting, so I can just keep a defendant on probation forever, or I don't ever need to follow this statute.
Okay.
Counsel, aren't you really indicating that under the sentencing guidelines, when one is on probation, a sanction is punishment for failure to comply with probation, and any days served by the defendant during that sanction are credited against the sentence, but they don't modify the sentence?
Yes, Your Honor, that seems to be what I'm trying to say.
Other questions? Anything else, Ms. Chalmers?
No, thank you, Your Honor.
Okay. Thank you to both counsel. The court will take this appeal under advisement. We are now in recess until 1:30 this afternoon.